Good afternoon and welcome to the Tennessee Court of Appeals. We appreciate each of you agreeing to participate with us via Zoom for these oral arguments. We think it's the best way to conduct oral arguments and keep everybody safe at the same time. I will tell you that even though we're doing this by Zoom, the same rules, procedures, and protocol are in effect as if we were all standing in the courtroom together. Essentially, what that means is each side will receive 15 minutes to make its oral argument. If you're the appellant and you've requested rebuttal time from Mr. Hivner before today, you will receive that rebuttal time. Want to also remind you that this is being live streamed over the internet, and we'll also tell you that in the event that we have technological difficulties, which we certainly don't expect to have, if everybody will just remain calm, we'll work through that and we'll make sure that nobody's rights are prejudiced in any way. Before we get started, I want to introduce our panel for this afternoon. We have Judge Skip Frierson from Morristown, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Mr. Hivner, anything we need to take up before we get started?
No, Your Honor.
You may call the case.
Auto Owners Insurance versus Phillip H. Thompson III.
We will hear from the appellant. Is the appellant ready?
Oh, yes. Do I go ahead and start?
Yes. Yeah,
okay,
go.
Sorry. Good afternoon, Your Honors. May it please the court. My name is Kara Fitzpatrick, and I represent the appellant Auto Owners Insurance in this case. This appeal stems from a breach of contract debt collection case, and today we are asking the court to reverse the decision of the trial court in dismissing appellant's case with prejudice, as the court did not have grounds to do so, either under Rule 12.02 or Rule 56 of the Tennessee Rules of Civil Procedure. Just to give a brief overview of the case, the type of claim, it is an insurance policy. The insurance policy is the written contract between the parties. The appellee applied for insurance coverage, excuse me, from the appellant. The appellant provided an insurance policy for the business of the appellee, and both parties agreed to the terms and conditions of that policy. At the expiration of the policy effectiveness, the appellee did not make all payments towards the final earned premium, which was a breach of the parties' agreement, and therefore this is a contract and breach of contract case, which is outlined in the appellant's complaint. That leads me to my first point. Because the appellant alleged all the necessary elements to support a breach of contract claim in its complaint, the trial court erred by dismissing its complaint for failure to state a claim under Rule 12.02. It's clear on the face of the complaint that it's—
Counsel, is that what the trial court did?
Yes, Your Honor. Well, they mentioned 12.02.6 and also Rule 56. Based on the order—
Which one was it?
Based on the order, I really can't tell you which one it is. During the hearing, the judge said that it could be under either. It could be dismissed under either of the rules. Ultimately, I think she went with Rule 56.
Okay, and so what was the reason the case was dismissed under Rule 56?
According to the judge, it was that there were no material facts in dispute, and the motion to dismiss was ruled on as a Rule 56 summary judgment because there was evidence outside the pleadings that the court considered.
And the reason the case was dismissed was why?
I honestly don't know 100%. The court alluded to the fact that the claim was not a claim on an account. And other than that, based on her order, it was just that the plaintiff did not dispute the statement of undisputed material facts filed by the defendant, and they failed to state a claim upon which relief can be granted.
So I'm assuming that if I took the statement of undisputed material facts filed by the plaintiff and read those, then that would say that the defendant was entitled to judgment. Is that right? Isn't that the way summary judgment works?
Yes, Your Honor. It was the defendant's statement of undisputed material facts, but yes, with our response.
Okay, I apologize. I think I misstated that. But if I read the defendant's statement of undisputed material facts, I'm going to be able to plainly see that the defendant's entitled to judgment as a matter of law.
No, I don't believe so in this case. I do not think that the
Is that
statement.
the standard that we're looking at, though?
I'm sorry, what was that?
Isn't that the way you do this? This is a summary judgment motion, and we look at the statement of undisputed material facts, and then from that, we glean that the defendant's entitled to judgment as a matter of law.
Yes, Your Honor, that's what we would do, yes.
So, can you tell me why judgment was granted?
Based on the statement of undisputed facts of the defendant alone, I really can't tell you why judgment was granted because I don't think it was proper. The statement of undisputed facts, the defendant admits parts of our claim for breach of contract and then simply lists a reason why he disputes the audit results. So I guess the judge, to me, it seemed like she decided that just because we didn't dispute any of the facts, which we didn't because most of them were actually in support of our breach of contract claim, that the defendant wins, which is what we're saying was improper.
Did you file a motion to amend your pleadings?
I did not file a separate motion. I just included an alternate request for relief in my response to the motion to dismiss.
And what did the trial court rule on that motion?
She ruled that I needed to have a separate motion and a proposed amended complaint for her to consider a motion to amend. And
Was an order ever entered to that effect?
I don't believe she mentioned that in her order of dismissal. No.
Okay.
And that was in court. And I also made an oral request to amend the complaint in the hearing as well. But that was not included in the order.
Okay, go ahead.
Let me ask you, Mrs. Patrick, under this policy between the plaintiff and the defendant, why was it important to do an audit to make a final determination about the amount owed? Tell me about that. What provision in the policy required this audit? It doesn't seem like it's just plain automobile insurance coverage to me.
No, it is not. It is similar to a workers' compensation policy. It's a commercial general liability policy that would cover the defendant's employers for his contracting business, his construction business.
Mm-hmm.
So what happens is the insurer determines an estimated premium based on payroll, how much money the company's making at the start. Then they offer an insurance policy for a full year in advance. And then at the end of that policy period, they go back and look at what their actual risk was and exposure was based on the amount of work done, the amount of employees he actually had over the past year. And then they adjust the premium at the end. It might be that they need to return a refund or they charge a further premium based on the exposure during the last year. Well,
considering all of those things that have to be done to make a determination about what was owed, what was paid, why would this give rise to a sworn account claim as you file your lawsuit?
Why would it give rise? Well, We just used the sworn account to establish our set amount of damages that we are claiming we had, which that number was what was on the final earned premium after the audit. So that number is our definite damages. That's what we've always said we've been owed after the audit, and it's remained the same. So we just used the sworn account affidavit on our breach of contract complaint to establish those damages in the event there would not be a dispute or sworn denial filed.
Yeah, but even though you did the audit and you came up with a number, the insured could contest that audit. Couldn't the insured contest that and say, you got this wrong, it shouldn't be that amount?
Yes.
And you'd have to look at that, and somebody would have to make a determination about what is the correct amount.
Yes, right.
And normally with sworn accounts, you don't have that sort of activity, do you?
Right, but all of that takes place before we get to the filing suit point. He agrees to participate in the audit and provide the necessary documentation as required by the policy. And then if he disputes the audit, he gets a certain amount of time to fix it with the insurance company. So that all that takes place prior to it ever going to a law firm or us filing. So he had the opportunity to dispute it.
So in this instance, you filed suit on a sworn account. If the defendant disputes either the account or the amount that you're alleging is owed, what happens then under the sworn account?
Under the sworn account statute, that would only mean that we could no longer use that sworn account affidavit to conclusively establish our damages amount. At that point, we would then go to trial and have to bring further proof to establish our damages and wouldn't be able to get a default judgment based on that amount. But that's all it is.
So that only goes to the amount that eventually, if any is owed, what is owed. Is that correct? It doesn't do anything to the allegation that money is owed. It's just a determination of how much is actually owed.
Correct. It's just one piece of the elements of breach of contract. If a sworn denial is filed, then the sworn account affidavit doesn't matter anymore, basically, and it should be set for trial. And then the plaintiff would then bring more proof to prove its damages, its calculation of damages, and can no longer use that as its evidence of damages. So it doesn't change anything about the type of claim or the substance of the claim itself. It's just an evidentiary procedure by statute that can be used in the case that there's not a dispute.
Okay, thank you.
So ultimately, we have a breach of contract claim in our complaint. It's listed out all the elements, and if the defendant denied the account, it doesn't mean that we no longer have a claim anymore at all. And if there was any issue with the complaint specifically, we should have been given the opportunity to amend our complaint, and we were denied that as well.
All right, thank you. We will hear from the appellee.
Good afternoon, Your Honors. Jack Irvin for defendant appellee Phillip Thompson. Phillip Thompson is a sole proprietor roofer. He's a one-man shop. He purchased this policy, general liability policy, and his premium was $1,700. After the audit, auto owners found a remuneration figure of $457,168 in phantom unknown employees. They considered all of these employees roofers under the policy, which carry the highest remuneration premium figure. And they adjusted the premium from $1,700 to $61,488 based on these phantom employees. Mr. Thompson denied the audit. He submitted everything his agent asked for. His agent told him that they would work through it through an internal process, and then this lawsuit followed. And the lawsuit, to be clear, is not a breach of contract. It is a suit on a sworn account. They filed a suit on a sworn account with an affidavit saying Mr. Thompson owed $61,000 some odd dollars. Now, Tennessee courts have said that actions to determine contractual obligations are not properly brought as actions for recovery under a sworn account. That law is older than the Civil War. The Supreme Court has said that since 1856. And I have quoted several cases and supplied the court with several cases that follow it. The relevant quote is, "Certainly it was not the purpose of the legislature to so far abolish the rules of evidence to permit the plaintiff who might reside in a different county or state in every case where he might suppose he had a cause of action, either in tort or ex contractu, to set out his cause of action in the form of an account." That's what was done in this case. We filed a motion to dismiss, and because the complaint was so devoid of facts, we had to supply facts outside the record. Just to allow.
Excuse me for interrupting. Did the plaintiff in this case allege breach of contract?
No, we don't think they did. We think they had one cause of action, which was a suit on a sworn account. And I guess the question the court has to answer is whether or not a sworn account is a distinct and separate cause of action, or is merely a way of advancing a breach of contract claim. And we submit that that question's already been answered by the Supreme Court in the 1800s.
Did the trial court dismiss this case under Rule 12 or Rule 56?
Considered it under Rule 56 because the court considered matters outside the initial complaint.
Is that reflected in the analysis by the order of dismissal?
I believe it is. Now, appellant counsel is correct, and that the trial court said that she believed that it would be properly dismissed under either standard. She did say that it would be dismissed under Rule 12 or Rule 56, but ultimately her ruling was under Rule 56 because she considered matters outside the pleadings, and that's what Rule 12 instructs the court to do.
What the court said is, if I'm reading correctly, is the court finds that plaintiff has failed to state a claim upon which relief can be granted. Accordingly, the motion is well taken and should be granted. Is that correct?
Yes, Your Honor.
And how does that fit within the summary judgment analysis under Rule 56.04?
Well, Rule 12 instructs the trial court that when a trial court considers a 12.06 motion to dismiss for failure to state a claim and matters outside the pleadings are relied upon, then the court should dispose of it according to Rule 56, which is what the trial court did.
I understand, but Rule 56.04 says the trial court shall state the legal grounds upon which the court denies or grants the motion.
And that was done when the court found that they did not dispute any of our material facts, and that based on those statements of undisputed material facts, the plaintiff was not entitled to judgment as a matter of law.
Well, let me read you your material facts. Since 2016, defendant Phillip Thompson has been a contractor operating as a sole proprietor. In July 2016, Mr. Thompson purchased a commercial liability policy from Plaintiff Auto Owners Insurance. The policy was effective July 29, 16 through July 29, 2017. Policy was renewed the following year, effective July 29, 2017 through July 29, 2018. After a yearly audit, including review of Mr. Thompson's bank records, Plaintiff Auto Owners assigned a remuneration figure of $457,168 as payroll to unidentified subcontractors and classified them as roofers for purposes of the premium basis, claimed $470,468 in total payroll exposure, and adjusted the premium from $1,738 to $61,488. Mr. Thompson denies spending $470,460 on subcontractors. He denies ever hiring a roofing subcontractor. He disputes the methods and conclusions of the audit and denies that he owes the money sought by plaintiff in this lawsuit on a sworn account. That's what the court had in front of it, wasn't it?
That's correct, Your Honor. And those facts demonstrate that this is a contractual dispute and not a debt collection.
Well, Mr. Irvin, do you then agree that this dismissal with prejudice is only as to the claim of a sworn account, that their contract claim itself is still alive, and then it's just a question of the plaintiff filing a lawsuit alleging a breach of contract?
Except that there is no contract claim. They only raised one cause of action, action on a sworn account. They didn't sue for breach of contract.
Well, if they didn't sue for breach of contract, then that claim has not been heard then, has it?
I think it has, because it arises out of the same facts and circumstances in the same transaction. They would have had to bring that, they would have had to brought that claim initially.
Well, if you dispute a sworn account and say, as opposing counsel has suggested here a moment ago, they filed a sworn account, you filed something that disputes the amount that's owed or that anything's owed. Why is that still not a live controversy in front of the court?
Because in this case, all they sued for was a sworn account. And this is a breach of contract case. And they didn't sue for breach of contract.
Well, aren't they saying that you owe us money?
They are saying that.
Isn't that an account?
The Tennessee Supreme Court and the courts that have interpreted it say that a contract dispute is not properly brought as a suit on a sworn account. That's what this court has said.
And how long ago was that?
Originally, Western versus Mead and Company was 1856, but this court has interpreted it in Nickel v. Silas as recently as 2006, and the Middle District of Tennessee has interpreted and followed that same principle as recently as 2018.
Middle District. Are you talking about the federal court or the Court of Appeals?
Federal court, Your Honor.
Okay.
In the Nichols case, Mr. Irvin, that you cited support for your proposition, and in that case, there was no attached affidavit, was there?
That was the Chumley case.
Well,
In Chumley,
actually, I believe in both there was no attached affidavit, but go right ahead. You can answer.
I apologize. I didn't know that there was an affidavit missing in Nickel.
Now, so were those cases dismissed on sworn account because there was no attached affidavit rather than because it was some claim other than an account?
The Nickel case was actually a case involving venue. But in determining venue, the court had to look to what the action really was. And the court said that it wasn't properly brought as a sworn account, but there were other counts in that complaint. They actually sued for breach of contract, and the breach of contract is the claim that survived. And so they held that venue was proper where the breach of contract claim would have been proper. The Chumley case, the plaintiff failed to attach an affidavit, and that was ironically the same appellant's counsel that was involved in the Chumley case. They once again filed a suit on a sworn account. They failed to attach the affidavit, and the district court said that they moved to amend the complaint to attach an affidavit, and the district court said that the amendment would be futile because this is not properly brought as suit on a sworn account, and therefore the amendment would be futile and the case was dismissed.
But in Chumley, that dismissal was only as to a, quote, sworn account case. It did not, in effect, dismiss the contract claim, which they could later bring. Isn't that correct?
There wasn't a contract claim, just as in this case.
You said there wasn't a contract claim, as in this case, there is no contract claim?
That's correct, Your Honor.
There is no contract that was signed by your client that allows them to go back and conduct an audit to make a determination about the final amount of the premiums owed. There is no such.
No, there absolutely is a contract. What I meant was a breach of contract cause of action has not been alleged in this case.
Okay.
Plaintiff asserts that she asked the trial court to allow her to amend her complaint prior to the summary judgment hearing. What's your recollection of that?
Included in her response to motion for summary judgment or motion to dismiss, she said that if the court finds any deficiencies in the complaint, we would ask for the opportunity to amend. The law is clear that asking for an amendment in a response to a summary judgment is improper. Now, notably, a motion to dismiss is not considered a response of pleading for purposes of moving the court to amend. They could have simply filed an amended complaint and alleged a breach of contract cause of action. They didn't even need the court's permission, but they didn't do that. Instead, they merely asked that if the court found any deficiencies at the hearing on the motion, they should be allowed to amend, but they didn't proffer an amended complaint. They just left the court guessing. And what the court said is there's nothing before me.
The court did the court enter an order on that?
There was no pending motion. There was no order. There was nothing to rule on.
Okay, anything further?
That's all I have, Your Honor. Thank you.
All right, we will hear from the appellant.
When you look at our complaint, it clearly alleges that there was an agreement for the plaintiff to provide goods or services. Pursuant to the agreement, those services were provided to the defendant. Demand was made and it remains unpaid, and the failure of the defendant to make payment on the account constitutes a breach of the parties' agreement. As a result of the breach, the plaintiff had this amount of damages.
Are you reading from the complaint now?
Yes, Your Honor.
Okay.
It's common business practice to keep an accounting of an unpaid debt where money is in exchange for a good or service at the same time the service is given. It's just basic business practices. It's just an accounting of the amount that's owed when it's not paid in advance. That's all this is. So it just refers to the debt itself. It doesn't matter what kind of debt it is. It's an amount of the debt that is owed. That's what was pled. And that's why the account is there. Additionally, there's a nuance that was missed in all these cases that are saying a sworn account is not a separate cause of action. In all of those cases, two of them, the sworn account affidavit wasn't attached at all. But also, like in the Chumley case, the court said a sworn account cannot be used to establish the underlying liability. So in one of the cases, the court determined that there was not a contract claim because it was federal preemption preempted by federal statute. So all that was left was the sworn account with the damages amount. So they said you can't just rely on the sworn account of your damages to establish the underlying liability. We don't have that here. We know that there's a contract. The defendant admitted there was a contract. We're not asking the court to establish an underlying liability or that there is a liability on a contract. And in the Chumley case, there was the issue of the damages that went beyond the contract that he was claiming and that were not specific, consequential, special damages beyond the contract that were undetermined. There was not a determined amount. So it makes sense that a sworn account cannot be used to establish an undetermined amount of damages or establish a contract liability. Those cases differ from what we have here. Our amount has remained the same throughout the case. Thank you.
Well, I don't know that you can say that because, well, you say throughout the case, but when this first started, the amount of your claim was $1,700. And then after an audit, it goes to $61,000. That's maybe why it's not a sworn account, Ms. Fitzpatrick.
But that was before the complaint was ever filed and after the audit took place and the new amount was included.
Okay.
All right, thank you for your argument. We will take this matter under advisement and attempt to render an opinion at the earliest time convenient. We appreciate you again participating with us via Zoom. Mr. Hebner, anything before we recess to the call of the next case?
No, Your Honor.
All right, you may recess court.
This honorable court is now in recess until 3 p.m.
Thank you, counsel.
Thank you.